everyone. Good day, attorney. We are the case crackers from BSA 2B. Today, we will be discussing Title 15, Section 153, and Title 16, Sections 154 to 170 of the Revised Corporation Code. Meet our team, the members of Case Crackers consisting of 6 members. Introducing Ms. Jenjen Ribat, Mr. Luis Bench Mill, Ms. Georgia Prado, Ms. Mabel Quimado, Ms. Kirsten Sepp Wednesday Santos, and lastly, Ms. Janine Temprosa.
Greetings to every viewers. I am Jenjen Ribat from BSA 2B, and here I am the first one to report from the group Case Crackers, and I will discuss here the section 153 to 155 under the Revised Corporation Code in the Philippines. So without further ado, let us discuss first the section 153, which is all about the withdrawal of foreign corporations. So this is subject to existing laws and regulation which a foreign corporations is licensed to transact business here in the Philippines, and they are allowed to withdraw from the Philippines by filing a petition of withdrawal. So in here, for example, you have a business or corporation as a restaurant or McDonald's, for example, and they are licensed to transact their business here in the Philippines, and they are also allowed to withdraw their corporation in the Philippines by filing a petition of withdrawal of license if they wanted to. So, there is no certificate of withdrawal shall be issued by the Commission unless all of the following requirements are met. So in here, they provided us the prerequisites or requirements that they must fulfill in order for them to have the certificate of withdrawal. So in here, we have letter A, all the claims which have accrued in the Philippines have been paid to compromise or settled. So in here, you must have all of your claims in the business must have been paid or been settled already. And all of the taxes, in letter B, all of the taxes, imposed, assessments, and penalties, if any, lawfully due to the Philippine government or any of its agencies or political subdivision has been paid. So in here, if you have tax, imposed, assessment, and penalty that is legally owed by the Philippines government, any of its agencies or any political subdivision, it must have been paid already. So in lastly, letter C, the petition of withdrawal of license of license has been published once a week for 3 consecutive weeks in a newspaper of general circulation in the Philippines. So in here, you have to publish your petition once a week, 3 times consecutive, in a 3 consecutive week. So in order for you to have a certificate of withdrawal, and that's how your foreign corporation or the McDonald's will allow you to withdraw your license here in the Philippines. So on to the next one. So in here, we have the section 154 under the Revised Corporation Code, and this will tackle the investigation and prosecution of offenses. So the Commission may investigate an alleged violation of this code or rule, regulations, or order of any commissions, And so in here, the commissions may investigate any violations of the corporation code or fraud committed by the corporation itself or their officers or even their employees or employers. And here, the commission may publish its findings, orders, opinions, advisories, or information that concerns such violations as may be relevant to the general public or to the parties concerned, subject to the provisions of the Republic Act 10173. Otherwise, it is known as the Data Privacy Act of 2012 and other pertinent laws. So in here, the SEC or the commissions has the authority of to investigate or to look, it has the authority to investigate, to look into complaints or evidence of violations of the corporate laws and regulations. And the commission shall give reasonable notice to and coordinate with the appropriate regulatory agencies prior to any such publication involving companies under their special regulatory jurisdiction. So in here, they could also work with other law enforcements or any regulatory agencies during the investigations. So if there is a violation that has been found, the SEC can bring this case to the court for prosecution. So this is the section that ensures corporate accountability and helps it maintain ethical business practices in the Philippines. And lastly, we have the section that I will discuss is the section 155, which tackles the administration of oaths and subpoena of witnesses and documents. So in here, the commission, through its designated officers, may administer oaths and affirmation, issue subpoena and subpoena duces tecum, and they will take a testimony in any inquiry or investigation and may perform other acts necessary to the proceedings or to the investigation. And before that, the word subpoena is a legal document that provides the court evidences such as a person or a witness, or providing a document that provides, or rather, it presents as evidence. And this section is assisting in enforcing a corporate laws. And before someone testifies or makes statements in the court, the SEC has the authority to have them swear that they are providing a truthful statement, which is also known as the administration of oath. They may also demand that the people show up and discuss the information they have is regarding to the case. So, in order for them to have an investigation, rather those people who are in the corporation itself, the SEC may request that the people working inside the company may turn over their important files or records such as emails, financial reports, or any contracts that they may have. Let us say that a corporation was accused of selling fake shares to the investors. So in here, the commission will request the company's executives to have an oath and state their testimonies. They can demand the employees to testify their connection about the case and hand them their financial records or transaction to uncover the truth. Thus, this section 155 ensures the transparency, fairness, and accountability in corporate practices. And that's the end of my discussion. The other members of the case crackers will provide you another section under the revised Corporation Code. So let us hear from Mr. Bench Luis Mil about Section 156.
Section 156, Cease and Desist. Section 156 of the Code of Criminal Procedure 1973 empowers police officers to investigate cognizable offenses without prior approval from a magistrate. It can also involve magistrates ordering investigations under specific circumstances. A cease and desist refers to a legal demand to stop unlawful activities and avoid further violations typically used in civil disputes. So the purpose of Section 156 is to enable prompt investigation of cognizable offenses by the police and ensure justice is served efficiently, and to formally notify someone to stop unlawful or harmful actions and prevent escalation to legal proceedings. Examples of 156, Section 156 rather, is if a person files complaint with the police about theft, a cognizable offense, the police begin an investigation under Section 156. If the police are inactive, the complainant can request a magistrate to direct an investigation under Section 156. So another is if a copyright holder sends a cease and desist letter to a company unlawfully using their trademark, warning them to stop or face legal action. If the company continues, the copyright holder might pursue a formal case or press charges. Section 157, Contempt. So Section 157 of the Code of Criminal Procedure 1973 pertains to the procedures police must follow when they receive information about a cognizable offense. However, contempt refers to actions that disrespect or disobey court orders or undermine the authority of the court. So the purpose of the Section 157 is to ensure proper investigation of reported offenses and determine whether the allegations require further action or a report to the magistrate. It is also to uphold the authority and integrity of the judiciary by penalizing actions that disrespect the court or its orders. A scenario that happens mostly in Section 157 is when, upon receiving a report of burglary, the police visit the crime scene to verify the complaint, collect evidence, and prepare a report for the magistrate if required. And if a person refuses to comply with the court-ordered injunction or publicly criticizes a judge in a manner that disrupts juridical proceedings, they may be held in contempt of court. Section 158, Administrative Sanctions. So Section 158 of the Code of Criminal Procedure 1973 addresses how a police report is submitted to a magistrate after an investigation. However, administrative sanctions refer to disciplinary or corrective actions imposed by an administrative authority to enforce compliance with laws or regulations. So the purpose of the Section 158 of administrative sanctions is to ensure that investigation reports from the police officers are properly forwarded to the magistrate for juridical review. It is also to maintain regulatory compliance, address misconduct, and deter violations within organizations, governments, or businesses. Scenario that mostly happens or commonly happens in Section 158 is a police officer investigating a fraud submits a report to the district superintendent, who forwards it to the magistrate for further action, and a government employee who misuses public funds is suspended or fined by their department as a corrective measure.
Section 159, Unauthorized Use of Corporate Name Penalties. The unauthorized use of a corporate name shall be punished with a fine ranging from 10,000 pesos to 200,000 pesos. In Section 17, we discuss the approval and registration of corporate name wherein no corporate name shall be allowed by the Commission if it is not distinguishable from that already reserved or registered for the use of another corporation, or if such name is already protected by law, or when its use is contrary to existing law, rules and regulations. However, in Section 159 of the Revised Corporation Code of the Philippines, penalizes the unauthorized use of a corporate name. In simpler terms, it means that no one is allowed to use the name of an existing corporation without permission or without the proper permission. This protects legitimate businesses from being misrepresented or harmed by others pretending to be them. Example for this is there is a company called Tech Masters Corporations that sells electronics. A random person decides to open a business and starts calling it Tech Masters Electronics. Same name to the real one. Too similar to the existing. The random person uses the real company name without the company's approval. This can result to confuse customers into thinking the fake Techmasters Electronics is connected to the real company. If caught, this person can be fined between 10,000 pesos to 200,000 pesos, depending on how serious the violation is. This law ensures that businesses can operate without their entity or identity being stolen or misused. Section 160, Violation of Disqualification Provision, Penalties. When, despite the knowledge of the existence of a ground for disqualification as provided in Section 26 of this code, a director or trustee or officer willfully holds office or willfully conceals such disqualification, such director, trustee, or officer shall be punished with a fine ranging from 10,000 pesos to 200,000 pesos at the discretion of the court, and shall be permanently disqualified from being a director, trustee, or officer of any corporation. When the violation of this provision is injurious or detrimental to the public, the penalty shall be a fine ranging from 20,000 pesos to 400,000 pesos. Section 26 of Revised Code Corporation provides thus: Section 26, Disqualification of Directors, Trustees, UIB, disqualified from being a director, trustee, or officer of any corporation if, within 5 years prior to the election of appointment as such, the person was A. Convicted by final judgment of an offense punishable by imprisonment for a period exceeding 6 years, second, violating this code, and third, for violating Republic Act Number 8799, otherwise known as the Securities Regulation Code. Second, found administratively liable for any offense involving fraudulent acts. And lastly, C, by a foreign court or equivalent foreign regulatory authority for acts, violation, or misconduct similar to those enumerated in paragraphs and above. The foregoing is without prejudice to qualifications or other disqualifications which the Commission or the primary regulatory agency or the Philippines Competition Commission may impose in its promotion or good corporate governance, or as sanction in its administrative proceedings. To expound, Section 160 of the Revised Code Corporation, or rather, Revised Corporation Code, penalizes directors, trustees, or officers who knowingly take or stay in their position despite being disqualified. It ensures that people who aren't eligible to serve in these roles can hide their disqualifications and continue in office. If they do, they'll face fines and be permanently banned from holding any similar position in the future. Example for this is imagine Jay is elected as a director of a company. However, Jay has a disqualification under the law, such as he was convicted of fraud in the past. Also, he owns share below the required amount for directors. And lastly, he's a government employee prohibited from holding corporate office. Despite knowing this, Jay hides his disqualifications and continues to serve as a director. Jay can be fined between 10,000 pesos and 200,000 pesos. He will also be permanently banned from serving as a director, trustee, or officer in any corporation. Section 161, violation of duty to maintain records to allow their inspection or reproduction penalties. The unjustified failure or refusal by the corporation or by those responsible for keeping and maintaining corporate records to comply with sections 45, 73, 92, 128, 177, and other pertinent rules and provisions of this code on inspection and reproduction of records shall be punished with a fine ranging from 10,000 pesos to 200,000 pesos. At the discretion of the court, taking into consideration the seriousness of the violation and its implication, when the violation of this provision is injurious or detrimental to the public, the penalty is a fine ranging from 20,000 pesos to 400,000 pesos. The penalties imposed under this section shall be without prejudice to the Commission's exercise of its contempt power under Section 157 hereof. The section mentioned that for compliance were Section 45, adoption of bylaw, Section 73, books to be kept, stock transfer agent, Section 92, list of members and proxies place of meetings, Section 128, records in lieu of meetings, Section 177, reportorial requirements of corporations. Expounding Section 161 of the Revised Corporation Code requires corporation to properly keep their records and allow inspection or reproduction when needed. If they fail to comply without a valid reason, they can face fines. This law ensures transparency and accountability within corporations. Protecting shareholders and the public. Example for this is, imagine B is a shareholder in a corporation called BC Corporation. As a shareholder, B has the right to inspect certain company records like financial statements or meeting minutes. Under the law, B requests to see these records because she wants to see or to ensure the company is handling its finances correctly. However, the company's management refuses to let B see the records without giving a valid reason. If the refusal is unjustified, the company or the person responsible can be fined 10,000 pesos to 200,000 pesos. Depending on the severity of the violation. If the refusal causes harm to the public, example, the refusal hides fraudulent activities that affect investors, the fine increases to 20,000 pesos to 400,000 pesos. Additionally, the SEC can use its contempt powers meaning they can enforce stricter penalties or even legal actions if the corporation doesn't comply. This law ensures corporations are transparent with their records so shareholder and the public can trust the company and hold accountable if something goes wrong.
Good day everyone, I'm Amabel Quimado and today I'll be discussing Section 162 to 164 of the Revised Corporation Code of the Philippines. These sections highlight the responsibilities and liabilities of individuals in corporate governance, particularly when it comes to accurate and truthful reporting. For these sessions, let's begin with Section 162 and explore its importance in fostering transparency and accountability within corporations. Section 162 focuses on the penalties imposed on individuals who knowingly certifies incomplete, inaccurate, false, or misleading reports required under the Revised Corporation Code. These reports may include financial statements, annual reports, or any other submissions mandated by law. When someone certifies a report, it means they are attesting to the accuracy and truthfulness of information contained within it. However, if the person certifying the report is aware that the information is incomplete, false, or misleading, they can face serious consequences. The law imposes two levels of penalties for violations. The first one is basic penalty. If the false certification is not considered harmful to the public, the individual involved may be fined 20,000 pesos to 200,000 pesos. The second one is stricter penalty for public harm. If the false certification is deemed injurious or detrimental to the public, the penalties become more severe. In such cases, the responsible party, which could be the auditor, accountant, or any individual involved, may be fined anywhere from 40,000 pesos to 400,000 pesos. Why does this matter? In the corporate world, transparency and trust are critical reports submitted by corporation are not just for internal use. They are often used by stakeholders, investors, regulators, and even the public to make decisions. A single misleading report can cause significantly harm such as financial losses to investors or shareholders, undermining public trust in the corporation or even the corporate system as a whole. Legal and reputational risks to the company and its officers. To prevent this outcome, Section 162 emphasizes personal accountability. It ensures that individuals involved in corporate reporting understand the gravity of their role. Certifying false information isn't just a clerical error. It's a deliberate act that can have far-reaching consequences. By imposing these penalties, the Revised Corporation Code aims to uphold the integrity of corporate governance, deter individuals from engaging in fraudulent practices, and foster a culture of honesty and accountability within organizations. So, to summarize, Section 162 is all about ensuring that corporate reports are truthful and reliable. It sends a strong message. If you're certifying a report, you have a legal and moral obligation to ensure it's accurate, as any failure to do so can lead to serious consequences, not just for you but for the public and the corporate as well. With that, I hope you now have a clear understanding of what Section 162 entails and why it's so important. Now let's move on to Section 163 where we'll dive deeper to additional aspect of corporate accountability and compliance. Thank you. Section 163, Independent Auditor Collusion Penalties. Section 163 of the law deals with penalties for independent auditors who engage in collusion with a corporation's director or representative to falsify financial statements. Under this provision, an independent auditor who collaborates with corporate officials to certify financial statements that are incomplete, inaccurate, fail to provide a fair and accurate representation of the corporation's financial condition, or contain false or misleading information, will face penalties. The basic penalty for this offense includes a fine ranging from 80,000 pesos to 500,000 pesos. However, if the certified financial statements is found to be fraudulent or causes harm to the general public, the punishment becomes more severe. In such cases, the auditor or responsible officer may face a fine ranging from 100,000 pesos to 600,000 pesos. These provisions highlight the importance of honesty and accuracy in corporate financial reporting. It aims to prevent collusion between independent auditors and corporate officers that could mislead stakeholders and harm the public. By enforcing strict penalties, the law ensures that auditors remain independent and fulfill their ethical duty to provide truthful and unbiased assessment of a corporation's financial health. This is essential for fostering transparency and accountability and trust in the financial system. That concludes Section 163. Now let us proceed to Section 164 to further our understanding of corporate accountability and compliance. Thank you. Understanding Section 164, Fraudulent Corporate Registration. Section 164 of the law addresses penalties for obtaining corporate registration through fraud. This provision plays a crucial role in ensuring honesty and fairness in the corporate registration process. Under this law, anyone found guilty of forming a corporation through fraudulent means or anyone who assisted in the fraud directly or indirectly faces significant penalties. The penalties are as follows. The first one is yung basic penalty, a fine ranging from 200,000 pesos to 2 million pesos for fraudulent corporate formation. The second is enhanced penalty if the violation causes harm or is detrimental to the public. The fine increases to a range of 400,000 pesos to 5 million pesos. These provisions emphasizes the importance of integrity during the corporate formation process. Fraudulent registration not only undermines the credibility of the business environment but can also harm investors, stakeholders, and the general public. By imposing strict penalties, the law acts as a deterrent, ensuring that individuals involved in corporate registration uphold ethical practices and comply with legal standards. This safeguards public trust in the corporate system and promotes a fair, transparent business environment. That's all for Section 162 to 164. Thank you for listening to my report. I now turn you over to the next reporter. Thank you.
Good day, everyone. My name is Kirsten Stevens de Los Santos from BSA 2B. And today I will be discussing about Section 165, 166, and 167 of the Revised Corporation Code. First, let's start with Section 165, which is Fraudulent Conduct of Business Penalties. So it is a corporation that conducts its business through fraud, and it shall be punished with a fine ranging from 200,000 pesos to 2 million pesos. When the violation of this provision is injurious or detrimental to the public, the penalty has a fine ranging from 400,000 pesos to 5 million pesos. This provision penalizes corporations that engage in fraudulent business practices. So, for example, if a corporation is found conducting its business through fraudulent means, it will face a fine from 200,000 pesos to 2 million pesos. Whereas if the fraudulent conduct causes harm or is detrimental to the public, the fines are significantly increased to a range of 400,000 pesos to 5 million pesos. So this law imposes financial penalties to deter fraudulent practices by corporation. The higher fines from public harm reflect the seriousness of offenses that negatively impacts society. This provision emphasizes corporate accountability and promotes ethical business practices. Let us now move on to Section 166 of the Revised Corporation Code, which is acting as intermediaries for graft and corrupt practices penalties. So it is a corporation used for fraud or for committing or concealing graft and corrupt practices. As defined under pertinent statutes, it shall be liable for fine ranging from 100,000 pesos to 5 million pesos. When there is a finding that any of its directors, officers, employees, agents, or representatives are engaged in graft and corrupt practices, the corporation's failure to install A. Safeguards for the transparent and lawful delivery of service, and B. Policies, code of ethics, and procedures against graft and corruption shall be prima facie evidence of corporate liability under this section. For example, we have Company X. A construction firm was binding for a government infrastructural project where one of its executives, Mr. A, offered bribes to government officials to secure the contract. During an investigation, it was revealed that Mr. A acted on behalf of the company, and Company X had no anti-corruption policies, code of ethics, or preventive procedures in place. The absence of these safeguards made the corporation liable for Mr. A's corrupt actions. As a result, Company X was fined 3 million pesos for being an intermediary in graft and corruption, while Mr. A faced individual criminal charges. The last section that I'll be discussing is Section 167 of the Revised Corporation Code, which is engaging in intermediaries for graft and corrupt practices penalties. So it is a corporation that appoints an intermediary who engages in graft and corrupt practices for the corporation's benefit or interest shall be punished with a fine ranging from 100,000 pesos to 1 million pesos. So this provision emphasizes that corporations cannot avoid liability by using third parties to commit corrupt acts on their behalf. For example, we have ABC Corporation. ABC Corporation hired an external consultant named Mr. Y to assist in securing a government contract. Unknown to the public, Mr. Y bribed a government official to ensure that ABC Corporation would win the bidding process. During an investigation, it was discovered that Mr. Y acted as an intermediary for ABC Corporation's benefit. Since Mr. Y's corrupt actions were done to serve the corporation's interest, and ABC Corporation knowingly engaged him, the company was fined 500,000 pesos under the law. This case demonstrates how corporations can be penalized for the corrupt actions of intermediaries working on their behalf.
Section 168, or tolerating graft and corrupt practices penalties. A director, trustee, or officer who knowingly fails to sanction, report, or file the appropriate action with the proper agencies allows or tolerates the graft and corrupt practices or fraudulent acts committed by a corporation directors,
trustee or officers or employees shall be punished with amount of ranging from 500,000 pesos to 1 million. So, in this section, who is the subject to this provision? There are the directors, trustees, and officer of the corporation. What action or inaction are penalized? First is the failing to sanction or take disciplinary action. Second, this will be knowingly failing to report the informal authorities. Also, number 3, failing to file the appropriate action, initiate legal proceeding with the proper agencies, and allowing or tolerating graft practices or fraudulent acts committed by the other directors or trustee or officer or employees of the corporation. What are the penalties that they can get? A fine ranging from 500,000 pesos to 1 million pesos. The purpose of this provision is the goal to hold the higher ranking corporate individuals accountable for not addressing legal activities within their organization. And also, it aims to promote ethical behavior and compliance with the law by ensuring that those in position of authority take responsibility for preventing and addressing graft and corruption. So, Section 169, or retaliation against whistleblower. A whistleblower refers to any person who provides truthful information relating to the commission or possible commission of any offense or violation under this code. So, any person who knowingly and with intent to retaliate commits acts detriment to a whistleblower, such as interfering with the lawful employment or livelihood of the whistleblowers, shall, at the discretion of the court, be punished with a fine ranging from 100,000 pesos to 1 million pesos. So, in Section 169 is a provision that protects whistleblower from retaliation. It outlines the penalties for anyone who tries to harm or retaliate against a person who reports violating or offenses. So, a whistleblower is a person who provides truthful information about the commission or possible offense or violation under the law. Provision action is retaliate acts like interfering with the employment or livelihood. The penalties taken have is to pay 100,000 pesos to 1 million. So, what are the protect of whistleblowers? This is a shield individuals who report illegal activities from the retaliation, also promote the transparency or encourage reporting of offenses, ensuring accountability and safeguard of the corporation. Section 170 or other violation of the code separate liability. So violation of any of the other provision of this code or its amendment not otherwise specifically penalized therein shall be punished by a fine of not less than 10,000 pesos or more than 1 million pesos. The same way, after the notice of hearing be dissolved is appropriate proceedings before the commission, provided that such a dissolution shall not preclude the institution of appreciation action against the director, trustee, and officers or the corporation responsible for the said violation. Provided further that nothing in this section that be constructed to repeal the other causes of dissolution of a corporation provided in this code. So Section 170 deals with the penalties for violation of any provision of this code that are not specifically addressed for elsewhere. It sets out fines and potential consequences for corporation and individuals responsible for such violation. So what is fine? Fine any violation of the code not otherwise penalized will result
in a fine ranging from 10,000 pesos and not exceeding to 1 million pesos. So, the corporation consequences is a corporation found in the violation may be dissolved after a notice in the hearing. So, what is individual liability? Directors or trustee or officers responsible for the violation can still face legal action even if the corporation is dissolved. So, this provision ensures that all violation and penalties maintaining the integrity and enforcement of the code.
So this concludes our report for Title 15, the Foreign Corporation Section 153, and the Title 16, the Investigation, Offenses, and Penalties Section 154 to 170. All pertinent details have been duly noted. If there are any concerns or supplemental information required, please advise promptly. Thank you for your attention to this matter.